The Supreme Court of the United States just issued a 5-4 order that has sent shockwaves through the ongoing legal battle between the state of Texas and the federal government over the southern border. And if you think this is just another procedural court ruling that doesn't affect your daily life, I want you to stay with me through this entire video, because what has just happened at the Supreme Court level has enormous implications, not just for Texas, not just for the border, but for the balance of power between state governments and the federal government across the entire country. This ruling touches something fundamental about how our constitutional system is supposed to work. And the legal battle that is now developing in the wake of this order is one of the most consequential disputes in recent memory. Today, we are going to break down exactly what that 5-4 Supreme Court order said, why it matters, what Governor Abbott's response means constitutionally, and perhaps most importantly, what the Biden administration is now trying to do in the aftermath of this ruling to get this entire case thrown out before it ever reaches a final decision on the merits. There is a lot happening here on multiple fronts simultaneously, and by the end of this video, you are going to have a clear and complete picture of where this legal battle stands right now and where it is almost certainly headed next. Let's start with the background, because you cannot understand the significance of the Supreme Court's 5-4 order without understanding how we got here and what the lower courts have been doing with this case. The case at the center of all of this is Department of Homeland Security versus the state of Texas. The core dispute involves concertina wire, also called C-wire or razor wire, that the state of Texas installed along approximately 29 miles of municipal and private land in the Eagle Pass area along the southern border. Texas put that wire up as a physical barrier to deter illegal crossings. The federal government under the Biden administration wanted the ability to cut that wire, remove it, or otherwise interfere with it. Texas said absolutely not. And that disagreement launched a legal battle that has now climbed all the way to the United States Supreme Court. To understand the procedural history here, you need to know the difference between the types of relief that courts can grant. When Texas first went to the lower federal district court, they asked for a temporary restraining order, often abbreviated as a TTRO, which is essentially an emergency pause on a particular action while the court figures out what to do next. The district court granted that TTRO, which barred the federal government and Border Patrol from interfering with the Texas razor wire except in genuine medical emergencies. That was a temporary win for Texas, but it was only ever intended to be a short-term measure while the case developed. Texas then sought a preliminary injunction, which is a more durable form of court-ordered protection that would prevent the federal government from cutting the wire while the entire underlying lawsuit worked its way toward a final decision on the merits. The district court denied that preliminary injunction request. But here's what makes that denial interesting and significant. The judge actually agreed with Texas on several important factual and legal points. The court rejected the federal government's argument that cutting the wire was necessary to respond to medical emergencies. The judge found that the notion that destroying the fence would help prevent medical crises didn't hold up under scrutiny. The court also rejected the idea that cutting the wire in one location and then leaving that gap open indefinitely was justified by a single emergency situation. You don't tear down a fence for one person and then leave it open for everyone who comes after. Despite agreeing with Texas on those key points, the district court still denied the preliminary injunction on other grounds. Texas immediately appealed that denial up to the Fifth Circuit Court of Appeals and simultaneously asked the Fifth Circuit to grant a temporary injunction just to maintain the status quo, to keep things as they were while the appeal was being heard. The Fifth Circuit granted that temporary relief, and that is the specific action that the Biden administration took to the Supreme Court on an emergency basis, asking the justices to step in and vacate what the Fifth Circuit had put in place. Now we get to the Supreme Court order itself, and this is where everything gets consequential. The emergency application initially went to Justice Alito, who handles emergency applications arising from the Fifth Circuit. He referred it to the full court, and the Supreme Court issued its 5-4 order granting the Biden administration's request. The order vacated the Fifth Circuit's temporary injunction, effectively allowing the federal government to resume cutting the razor wire that Texas had installed. The 4 justices who would have denied the application, who would have kept the Texas wire in place, were Justice Thomas, Justice Alito, Justice Gorsuch, and Justice Kavanaugh. The 2 justices who crossed aside with the liberal bloc of the court and grant the federal government's request were Chief Justice Roberts and Justice Barrett. Now, I want to be precise about what this order does and does not mean, because there is a great deal of confusion about this in public commentary. This is not a final ruling on the merits of the case. The Supreme Court did not hold a full briefing, did not hear oral arguments, and did not issue a majority opinion explaining its reasoning in depth. This was an emergency application, a procedural intervention at a preliminary stage of litigation. The court was asked whether to maintain the status quo while the case continues to develop, and 5 justices said no. That is significant, but it does not mean the Supreme Court has definitively ruled that Texas has no right to install border barriers, or that the federal government has unlimited authority to destroy state-erected infrastructure. The underlying legal questions remain very much open and unresolved. But here's why the ruling still matters enormously, even as a procedural order. It signals where at least 5 members of the current Supreme Court stand on the question of whether Texas's temporary injunction should have been in place. It gives the federal government a practical win, the ability to cut the wire right now while the case is still being argued. And it has triggered a chain of events that is now unfolding at the lower court level with significant speed and urgency. Governor Greg Abbott's response to the Supreme Court order was immediate, forceful, and constitutionally significant in its own right. Abbott issued a letter to the Biden administration making a bold and specific legal argument. He invoked Article 1, Section 10, Clause 3 of the United States Constitution, the provision that deals with states engaging in war or self-defense. The governor's position is that the federal government has so thoroughly failed to fulfill its constitutional duty to protect Texas against what he characterizes as an invasion, that the state of Texas is legally justified in taking defensive action on its own authority. In other words, Abbott is arguing that regardless of what the Supreme Court said in its emergency order, the underlying constitutional authority for Texas to defend its border exists independently of whatever the federal judiciary decides about razor wire injunctions. This is a significant constitutional argument. Article 1, Section 10 is a provision that is rarely invoked and rarely litigated at this level, and the governor putting it at the center of Texas's legal and political strategy elevates this dispute beyond a simple argument about who gets to cut off a fence. It frames the entire border dispute as a question of state sovereignty and the limits of federal power. And that framing is one that is going to resonate in the courts as this case continues to develop. Whether you agree with the governor's position or not, the constitutional argument he is making is a serious one that deserves serious engagement. The question of when a state has the right to act in self-defense under Article 1, Section 10, when it believes the federal government has abandoned its protective responsibilities, is not a question with an obvious or simple answer. It is exactly the kind of question that the Supreme Court will ultimately have to address when this litigation reaches its final stages. After the Supreme Court's 5-4 order, the Fifth Circuit responded by doing something that added another layer of complexity to an already complicated situation. The appeals court held the case in abeyance, essentially pausing its own review, and sent the matter back down to the federal district court for 60 days. The purpose of this limited remand was for the lower court to develop additional factual records and evidence that the Fifth Circuit believed it needed in order to properly evaluate the underlying legal questions. Oral arguments were held at the district court level during this remand period. And one of the genuinely interesting questions that emerged from those proceedings was the scope of what the district court was actually authorized to do during the limited remand. Was the lower court only supposed to develop new factual evidence for the Fifth Circuit to review, a record-building exercise? Or did the district court also have the authority to issue a new judgment based on all of that newly developed evidence? That distinction matters enormously because a new judgment at the district court level could potentially change the trajectory of the entire case, either in Texas's favor or against it, before the Fifth Circuit even has a chance to weigh in again. And here is where things get truly concerning for anyone who believes that this case deserves to be fully litigated and decided on its merits. The Biden administration is not content to simply defend its position on the razor wire. It is using the 60-day remand window as an opportunity to try to have this entire lawsuit dismissed before it ever reaches a final decision. The administration filed a motion to dismiss, arguing that the entire case should be thrown out on jurisdictional and substantive grounds. Their arguments are layered and technical, but the overall thrust is straightforward. They want the court to find that Texas does not have a valid legal claim that can proceed forward, and they want that determination made now during this limited remand period rather than allowing the case to continue developing toward a final ruling. Specifically, the Biden administration argues that sovereign immunity bars Texas's state tort law claims that the Administrative Procedure Act claims fail because Texas is not challenging a final agency action as required by law, and that Texas has not met the legal bar required to proceed with its constitutional claims. They invoke the Supremacy Clause, the provision of the Constitution that establishes federal law as supreme over state law when the two conflict as an additional basis for dismissal. Administration is essentially arguing that Texas's entire legal theory is fatally defective on multiple independent grounds and that no amount of additional factual development is going to fix those defects. What makes this motion particularly aggressive is the timing. The administration is filing this dismissal motion during a 60-day window that the Fifth Circuit created specifically for the limited purpose of developing evidence. Using that window to seek outright dismissal of the entire case is a litigation strategy designed to win before the clock runs out, before the Fifth Circuit gets the case back, and before any of these genuinely difficult constitutional questions have to be answered by a higher court. It is a legal maneuver that says, in effect, we got a favorable ruling from the Supreme Court on an emergency basis, and now we want to leverage that procedural win into a permanent outcome before Texas gets another chance to argue its case. Meanwhile, it is important to understand that this lawsuit is not the only Texas border legal battle currently in play. There is a separate and distinct dispute involving Texas Senate Bill 4, the state law that would allow Texas state law enforcement to arrest individuals who cross the border illegally under state authority independent of federal immigration enforcement. That case was argued in front of a separate 3-judge panel at the Fifth Circuit, and the track record and posture of that litigation suggests that the panel is likely to side with the Biden administration on the injunction question there as well. So Texas is fighting on 2 separate legal fronts simultaneously at multiple levels of the federal court system against a federal administration that is aggressively using every procedural tool available to prevent these cases from reaching final decisions on the merits. And in both cases, the ultimate destination is almost certainly the same place back at the Supreme Court of the United States. These cases are in a very real sense destined for the Supreme Court again. The constitutional questions at stake are too significant, too contested, and too unresolved for the lower courts to provide final answers that both sides will accept. The question of whether a state can erect physical barriers at its own border when it believes the federal government has abdicated its protective responsibilities. The question of whether Article 1, Section 10 gives states a meaningful right of self-defense against what a governor characterizes as an invasion. The question of how far federal supremacy extends when states believe the federal government is actively failing in its constitutional duties. None of these questions have clean, simple answers, and none of them are going to be resolved permanently at the district court or even the Fifth Circuit level. What we are watching right now, the 5-4 emergency order, the remand, the motion to dismiss, the parallel SB 4 litigation, is the early chapter of a legal battle that is almost certainly going to require the Supreme Court to step in again, possibly on another emergency basis, and eventually to address these foundational constitutional questions in a full and final way. The stakes here extend well beyond Texas and well beyond the southern border. What is being litigated in these cases is a fundamental question about the structure of American federalism, about what states can do when they believe the federal government has failed them, and about the limits of federal power to override state action taken in the name of self-defense and public safety. However, this ultimately resolves the legal principles that emerge from these cases are going to shape the relationship between state and federal authority for decades to come. This is one of the most consequential legal battles currently unfolding in the American court system, and it is moving fast. We are going to continue following every development as it happens. The district court's response to the dismissal motion, whatever the Fifth Circuit does when the remand period ends, and any further Supreme Court involvement as these cases push toward their ultimate resolution. Drop your questions and your thoughts in the comments below. As always, thank you for watching, and never forget, this nation was built by scholars, and this nation will be maintained by scholars.